In a moment, we will hear from our first speaker, Professor Modi, from the Faculty of Law at the University of Baroda. We're delighted to have him with us. I can say I'm not going to follow Amina's practice. I hope she doesn't mind of doing fuller introductions. There are very good biographies in the documentation for the conference, but we should try to maximize the amount of time we have available to hear our speakers and to discuss with them. So as I say, in a moment, we'll be hearing from Professor Modi, who will be followed by Professor, excuse me, I was losing track of who's dropped out. I'm so sorry. By Professor Nanda from Bennett University. And Professor Banda will be followed by a doctoral researcher, Dieter Marchesi, at the Flanders Research Institute at Leuven, not so far from London here. So these are a disparate range of interventions, and I think they will all give us important insights into the study and work and relevance of the Commission. So forgive me for my slightly halting start. I'm wrestling slightly with screens at this end, and my, for some unknown reason, action has decided that it's being slightly eccentric this morning. So forgive me for my slightly halting and jerky start. But Professor Modi, perhaps you can kick us off. We'll have 3 presentations, and then hopefully have good time for discussion.
Yes. Yeah. Thank you for that nice introduction, and allow me to present on the topic, which is I find very much relevant. That I think my topic I have chosen from the historical background is role of United Nations War Commission in preventing war crimes. So I have chosen this topic because I wanted to understand that before that genocide conventions and all other instruments, there was an instrument called United Commissions and War Crimes, and how was that working? And what are the cases that which was dealt by? And if you will go to the archives, you will find as many number of cases, but I have chosen few cases to discuss. Apart from that, I will discuss few historical background, and lastly, I will come to the conclusion. So as a researcher, I have put out the 3 questions. One question is, what is the meaning of war crimes? When and how the UNCC has been evolved and developed in little span of time between 1943 to 1948. Actually, it was established in 1943, but earlier, in 1937, the draft was prepared, and that draft was prepared, and after the preparation of that draft, that it was established in 1943. Then other question I will discuss here is the what are the cases from the archives which we can take and understand that whether that UNWCC has been achieved its purpose or preventing war crimes, and lastly the same, that how whether it's achieved its purpose or not. Basically, introduction part is very long, because I think if I will go into the detail, then there is so much history from San Francisco Conference and human rights perspectives, which we can discuss in later on the other part. But here my focus is on the war crimes, and specifically United Commissions for the investigations of the war crimes. So basically on 20th October 1943, a diplomatic conference in London attended by allied governments, which was set up by the United Commission for this. So the commission has examined questions and established the International Court for the Trial of War Crimes. So I think this was the questions which was after we have seen the Holocaust and everything from the 1939, that World War was happening, and a lot of that inhuman activities what happening, and that everybody is are aware about the crime against humanity, certain things which has been committed by the Germany in the Eastern European country and the European countries specifically, and that was a concern for the whole world community, that what should be the things which we should come with and what are the solutions we can derive from that. And that's why court approved that United for the Crimes Court approved by on 26 September 1944. These are the certain historical facts which is available on even UN website or certain basic things you might be aware about. But I find we should, I should mention these things, and this is about that how many number of that nationals, high contracting parties, that qualifications was decided, designated 3 qualified person as a members to the British Foreign Secretary, who called as a conference in London in representative parties convention. So this was something which is something historically. As to the jurisdiction of the court, draft convention provides the jurisdiction of court shall be extended to trial and punishment of any person irrespective of rank, position, who is committed or attempt to committed or has ordered, caused, aided, abetted, incited any person commit by his failure to fulfill duty incumbent upon him, has himself committed offense against the law and the customs of the war. So this is very important things when we understand the jurisdiction. And I think panel has also discussed about universal jurisdiction, and from that we can take out that International Criminal Court and other the court has been established which cover all the aspects. But earlier, that at that time, that it was very initial phase. So during that initial phase, it was very necessary steps to just lay down the foundation that how it will work. So these are, because I am a legal person, so I think certain things which I want to mention here, that the court has offense member, armed forces, civilian authorities or other persons, or authority or claim color of authority, or in concern with the state or other political entity engage in a war or armed hostilities with any of the high contracting parties in hostile operation of territory of any high contracting party, law to be applied by the court was defined, convention, treaties, international customs of war, principles of law of nations. So these are the certain things which is decided in international law. We find treaties, we find customs, customary practices. We find that there are, when the nation two law nations come and usage established among the civilized peoples, something. Then the criminal generalized, recognized by civilized, judicial decision, and lastly, responsibility for the prosecution was in general to rest with the government, bringing the case before the court. So I think this is one of the critical aspect, according to me, where here burden of proof that government has to bring the court. So this is something where that international United Nations War Commission has no power to initiate the investigation, that it is the government who will bring the issue. Diplomatic conference mentions and interested prosecution and preferred in own representative should not undertake. See, basically from 1944, I think one of the most important and discussed issue is the Nuremberg trial and the Tokyo trial, or trial which is known as a Far East trial, which is the most important trial, which has changed the history in terms of that international law or international criminal justice. It's a breakthrough case where every time when we discuss about this case, there are many number of questions comes. And when I study as a legal person, then the first question which come to us is that if the crime which has been committed in the past, whether we can punish someone, that law has not been established. So this was a question, and this is what that the question of jurisdiction was came, and that is why that the things which was decided in the tribunal where certain things, that is how they have used this. And on 1948, government of US, France, UK, Soviet Union, these are the countries which is like permanent member also. So in a London agreement providing establishment that that an international military tribunal for trial of war crimes of the European Axis, whose offense has no particular geographic. So even 19 other government has also adhered to this agreement. So Nuremberg trial I will not discuss because it is a separate subject in international law. Here we are talking about that whether that how war crimes and what was the role, what was the span of period where the certain cases was investigated. Another interesting about this Far East is in the declaration post-dem, the 26 July 19 made the United States, China, UK. So it was provided with respect to Japanese war criminals that stern justice shall be made out to war criminals, including those who have visited cruelties upon the prisoners. So I think this is another step where the Tokyo trial was happened, and that's Japanese government was responsible for that and certain things which we know. Now, I think most important article which we should discuss here is Article 6. As a research I think I have laid down the 3 questions. And one of the historical prospect I have discussed. Now I will be discussing that how war crime is defined and what were the issues which were not covered and should have been covered. So following act of any of them are coming within this jurisdiction tribunal shall be individual: crime against peace, planning, preparation, waging war, aggression, war in violations, international treaties, and common conspiracy, etc., etc. Then war crimes. I think I have mentioned that what war crimes is. So war crimes, namely violation of the law of custom of the war. Such violations shall include, but not limit to, murder, ill treatment, deportation, slave labor, any other purpose, civilian population, occupation territory, murder, ill treatment of prisoners of war, persons of sea, killing of hostage. I think everything has been discussed, but I think that's why the genocide convention came, because I think during Nuremberg trial, I think they were not able to define the crime which has been committed by the Hitler and the army. So that's why it was very necessary to come with the Lemkin has come with this the word genocide, which is a very different history, which is not part of our understanding right now. In addition to its power to try, punish individual, tribunal was authorized to declare group or organization of which a defendant was a member to criminal, with the light effect that individual could thereafter brought to trial and member. So here group is covered. But what was ironic in the tribunal of Tokyo, that the group was not discussed. These are the certain few cases. I'm not going to in detail notes and everything.
Can I just say, Professor, if you just give it 2 more minutes.
Okay. Thank you. So I will fastly go, and that this one trial of Albert Kissinger, that the accused with being that killing 335 Italian nations in the caves, and the accused was found guilty. So that this United War Commission has played very important role. Then this trial of Karl Borer Ernest. This is another important trial where accused were officer of German were engaged in the combat with the formation of the French force in interior, which became the major resistance movement during this. So again, this allied forces and certain things which was, and the other 2 accused were under the order. So this was something related, and the charge was that they have abused the power, and judgment was all members were found guilty except 2. And this is last case trial. That is why I have included few cases. The accused were member of German units who have took part in the series of crime against French population in June 1944. So all the accused were found guilty except. So this is another. So lastly, I would like to conclusion. So I have mentioned historical aspect. I have mentioned how war commission has been decided. I have also dealt with the few cases. But before that, I think the only conclusion which I came to know here, in spite of that, the importance of this war crimes commission, that it has that was constituted war has responsibility, but it is on the basis of the evidence of the government, and commission was proven little helpful to prevent inhuman atrocity because commission has no power to prosecute war criminal. They are identifying it. So thank you for patience listening. I hope I have not exceed my time. Thank you.
No, perfect. Thank you, Professor Modi. That was a fascinating survey, and indeed you point to the weakness of the commission very, very sharply, and I think you also point to both the vision, the vision but unfulfilled vision of the idea of the commission to develop an international criminal court, which of course never came into operation. It's now my great pleasure to ask Professor Nanda to join us, who will be speaking about the issue of the UNWCC and sexual and gender-based violence as international crimes and its significance and application to the modern day. So, Professor Nanda, the floor is yours, and welcome very much to this conference. You need to unmute, Professor.
Sorry, my bad.
It's all right. It's a crime I commit all the time myself, so don't be concerned.
Yeah, so I also missed that. So it's a crime committed by me also, in fact. So it's a very good evening from here in India. We have it 17 hours here. So, in this, I've heavily relied on the work which you have done in this field of UNWCC, as well as specifically written on also the sexual and the gender-based crimes. Now, taking a clue from there and also looking into the documents which are presented at the United Nations War Crime Commission, the website, in fact, I looked into a few of the data which were available and the trial which were committed, and have done a bit of my study on that, which is again undergoing, and I'm still struggling to read all the documents here to come to a certain conclusion. However, if you look at the way United Nations War Crime Commission has in fact split up, this is one of such commission where they have in fact criminalizes the sexual and gender-based violence. And if you look into that kind of way in which the sexual and gender-based, the crime has been looked into by the national courts who are undertaking the trial under the aegis of the United Nations War Crime Commission has been commendable. I am aware of the fact that at the time the SGBV term was not being in practice at that time, but when we look into the trial which we conducted, they in fact look into the violence against women at not only in the form of rape, but also in the different forms like enforced prostitution. We have in forced sterilization as well as a forced abortion as well as. So this in fact shows that the United Nations War Crime Commission was way ahead in its term of looking at the crime against women at that point of time, where the women were only considered to be victor's spoil and their right was not even regarded per se. Now, there are some examples, and I'm not going in detail because we know the name of those famous trials, in fact, but the cases like of Takasaki Sakai is there, and really sorry if I'm not able to pronounce the name correctly because it's not very similar to what I'm used to it, but then kindly correct me later on if I'm not able to pronounce their name properly. So you have Takasaki Sakai is there, where the Chinese military court looked into the violation by the leader with regard to the raping and mutilation of women and the nurses, where he not only committed by himself, but also allowed and permitted his subordinates to commit the same. So at that time when he was charged, he was not charged for the direct liability of him himself committing the rape, but also with regard to the superior command responsibility for letting his and not even preventing his commander soldiers in carrying on with that practice. After that, we have also one of such trial is there of Yoshio Yaki is there, which is tried by Australian military court. And again, at that time, not only the rape was punished, in fact, but also they looked into the ill treatment and the torture which was done in order to, in fact, commit the commission of rape. And the person was charged with torture as well as along with the rape for the, the commission of rape of that woman who was there in that particular trial. Apart from this, we have the Netherlands court which tried one person named as Washio Awachi with regard to enforce prostitution. And this was a case where for the first time also they're looking into where the person is compelling the woman, abducting them sometimes, or maybe forcing them, the women who are belonging to the poverty-stricken families into this prostitution and threatening them. And he was in fact punished with 10 years of punishment. One more, in fact, the stark thing to notice in this particular case is that it was not only Vashio Awachi which was being taken up, but also his subordinate, the mistress, where they're calling as, and the name is in fact some lies. Biton's name is there, and that lady was also being taken up, though was not charged and prosecuted in the same manner, but they accepted the role of even women who was in fact assisting Washio Awachi in conducting this kind of violation of war crimes. So enforced prostitution. Apart from this, we have the countries like Belgium, Chinese, Australia, and Netherlands, in fact, who have in their own statutes the commission of rape, abduction of girls, as well as enforced prostitution be designated as war crimes. So apart from this, in fact, there are a number of cases which has been done by the Polish Supreme National Tribunal, as well as the cases which were done by the US Military Tribunal in the case of Hoses and in the case of Ulrich Griffith, where they not only look into the violation of a woman in terms of rape or prostitution, but look into the genocide element with regard to the way they have been treated. So with regard to forced insemination, not only for women, but also for men, in fact, in that scenario, and also sterilization, which is being done of those class of people who they consider to be impure and therefore not allowing them to proceed, in giving birth to the child who considered to be the impure, in fact, and forced abortion as well. So these, and that time we looked into that United Nations War Crime Commission was not working in isolation. In fact, that was a time when the debate and discussion was going on with regard to the Genocide Convention also. So that shows that how the member countries and the staff who were in fact supporting the member countries were very much aware about what is the reality, what is going on in the outside world, and they were bringing that in the context of their trial at that point of time. This also brings me to the point is that when you look into the member state parties of United Nations War Commission, they are primarily the male-dominated members. There were a few states which were there who had the member of women, in fact, but not much of detail has been available with regard to the participation of women in the United Nations War Crime Commissions. However, irrespective of that, we see that so many such crimes have been looked into in the national jurisdiction of various countries who were member state of the United Nations War Crime Commission, and they were successful in putting them to trial and then prosecuting with as much punishment as they could have given for any other crime. The reason why I think that was possible, in fact, is that we can't look at the United Nations War Crime Commission in isolation. What I'm looking into, and I'm trying again finding out more document material to support what I'm saying, is that has to be looked in parallel with what was going on in the national level of various countries. That was a time when you had the World War I broke out, and you were in fact proceeding towards a World War II. Many of the women, in fact, movement was in place. They were fighting for their own political rights, and at the same time, they were not ready to, be stepped down from that particular level. So I believe that was also one of the reasons that why, when we don't have that much of a woman participation in the United Nations War Crime Commission, we still are in fact looking into this evidence of trials be conducted by various state members prosecuting not only rape, but various different forms of sexual and gender-based violence. Apart from this, it's not only the crime being present there and being prosecuted, also if you look into the elements which the trial courts, in fact, at the time of the trial, the courts have looked into, was also commendable. Though again, the United Nations War Crime Commission falls short of defining the offenses, falls short of, in fact, laying down the elements of different offenses which they're making as war crimes and commission and crime of against humanity. However, when I looked into the trial of again, a few of the trials, public trial, which I could in fact read in this particular time period, is that they are exercising that similar kind of precaution, similar kind of care, which any trial court would have exercised when they're dealing with such kind of issues with regard to the women's violation, the sexual and gender-based violence, right? So we have this case of, in fact, Heroes and Takata of USA versus Heroes and Takata. We have a case of USA versus Hamasaki, as well as USA versus Hima Mitisu. These are the cases where the prosecutor, in fact, as well as the member states of the court, in fact, were very much careful and watchful as to what kind of a question are being posed, and as to women as being made uncomfortable at the time of the trial being going. And they were very carefully watching the question from the side of the defense as well as question from the side of the prosecutor. And in one of the cases, we have Mr. Sweeney was there, who was a prosecutor side, and he in fact stated that when a person is saying that rape is being committed, that shows that there was also an attack, and that's where the rape is being committed. You don't have to again supplement with the proof that whether attack was also being there or not. So that was also one such thing has came out from the examination, the cross-examination of the witnesses that time. The another thing which has been looked into, though the trial which have had able to look into during this time, is that are making sure that they are very careful of and watchful of what kind of a question is being posed to, in fact, a victim. But there are cases where they are very much focusing about whether the victim struggled or not, whether the victim in fact crossed her legs or not. So there was one such case of trial of Tenichi Sakada, in fact, where the defense counsel was in fact raising these questions, which though later on being commented as not necessary, but were rather allowed to be posed at that time. So though they're very much aware about the elements of consent being there as one of the element, and that whether the force is being used or not, that they're trying to rely on the circumstances in which it has been done. But we see many of such questions are nevertheless being allowed to be posed. So on one hand, we are doing United Nations War Crime Commission has done a commendable job, but on the other hand, we see some kind of such things also has been stated. The same thing, in fact, though there was no such elements of crime being listed out in the elements of crime listed on the United Nations War Crime Commission. However, when we read the current the trials which are being conducted in the ICC, for example, and one such trial which I happen to see is the Bemba case, where we have the presiding judge, Judge Steiner was there. She, in fact, while the victim is being questioned with regard to the rape and the manner in which she was violated, she in fact made a point that when you are making such kind of questions, you have to keep in mind that we are not in fact posing insensitive and in fact uncomfortable questions to the witnesses. And the fact that, and in fact reading it from there, that the fact that the weapons are there with the accused persons, with the criminals, and the threat is being posed, they say that is a sufficient question for showing that the absence of consent. So, and this trial proceeding of Bemba cannot be seen in isolation from United Nations War Crime Commission. So the trials of United Nations War Crime Commission are in a way supporting the similar kind of practice at the time when you are trying a person for a sexual gender-based violence, and in fact we're interviewing and cross-examining our witnesses. One such thing, in fact, which is there, and I'll take just a few minutes to conclude that, is that one such thing which I've seen, in fact, with regard to the trials being conducted, though at the time when the discussion was being going on as how the trial being conducted, and member states agreed that they would keep and not disclose, in fact, the names of the witnesses, the victims, in fact. But when I happened to read the trial proceedings of few of the public trials, in fact, there the victim name was very much being put in front on the pages as who was a victim and what all things, and who were the family members, where the state they belong to. So that was one thing which I find has been stated in their discussion, but not been followed by the national jurisdiction when they were conducting the trial. And this is something which now at present, in fact, the ICC is very much sure of following that practice of keeping the privacy on, in fact, of the victims and the place, in fact, also from their will, where they belong to as in private. Also, the reason why, in fact, I believe that because only the major criminals have been coming into the ICC, and they're always very scared that their the soldiers or their junior people would come to these victims' houses and then again will harass them. So maybe that is one such reason which is there in present context, which may not be there in the time of the United Nations War Crime Commission, because the trials were commonly done by the victor state. So they were not that much afraid about, in fact, the violators or their subordinates again coming and again harassing the victims and their family. So that was one thing which I looked into. The another thing which, in fact, I looked into is the kind of criminal liability they have imposed on the people who have committed the crime. So it's not only the direct in fact, participation or the direct liability which they're imposing it, but in that they're also imposing the command liability, command responsibility, as well as to some extent joint criminal liability also. So that is also one way where I have to work on to look into that, how far we can say that the same has been applied or can be used in the present context. Because we, not that recent, but we recently have a case of, in fact, Bemba, where the later in the appeal court, they in fact have acquitted the person and not on the ground that they could not link the fact that he has not performed his duty as the commander. So that is where I would like to see as how the proceedings of United Nations War Crime Commission can later on be transported and looked into the way the ICC functions with regard to command liability and responsibility in terms of sexual gender-based violence. One more thing, in fact, is that during the trials, and the data is only limited, which I have it, is there are two trials, primarily one trial which I could find out is of Belson trial is there done by the British military court, where not only the men but also the women were also being tried equally with the equal punishment. So we had around 45 persons who were indicted there, and out of that, around 16 women were there who were also charged and prosecuted with as much severity as any male person. So in that context, the distinction was not being kept with regard to women and male. And if we see in the present context, that is somewhere we are lying back and not able to see as to whether women can also play the role of, in fact, a perpetrator. With regard to the women's being indicted with regard to the sexual-based violence, I only had one example, and the case which I looked into is Lies Betrots. In the case of Walchi case of Netherlands case, where she was also working, and as a mistress to that commander, but she was not indicted and prosecuted for the same crime. So, but nevertheless, it shows that the women were prosecuted and, in fact, has been equally punished for the crimes which were committed by the male SS members, right? Though not in the sexual gender-based violence, but nevertheless in the other areas. Just one, I'm really sorry that if I'm taking, I just need 2 or 3 minutes, if you could allow me to just summarize it. Can I take, thank you. So if we look into that why, and I was looking into is why we don't have Nuremberg and Tokyo having the similar kind of things in their statute when they were in fact parallelly being in fact created and the trial was being conducted. So that makes me think that maybe because the purpose for which the Nuremberg and the Tokyo tribunals were created was more of a political in nature, that they wanted to prove their, in fact, I would say the victors, in fact, wanted to prove their worth in terms of towards the war losers in that context. And that's where the majority of the statute which is being done was done with regard to the violation of laws of war, minus any such kind of violation which is done by against the women and against the common civilians. So that is the reason, because at the time when the discussion is being done at the United Nations War Crime Commission, and the document which states that they heavily relied on the preamble of Hague Regulation of 1907. And they say that the preamble can be used as a guiding factor, in fact, for saying that even if the act has not been made punishable, is not been taken to be criminal so far, can nevertheless be punished by the member states of the United Nations War Crime Commission. And that goes the same with the Nuremberg as well as the Tokyo, but they fail, fail in fact in that regard. So that is one such observation. Apart from that, as I stated, the movement, in fact, political movement which is being done by the women in the national courts has very much been reflected in the way the statutes of various member state countries are being reflected. So you have Belgium, Chinese, Australian, Netherlands, who have stated rape and such kind of sexual-based violence as to be war crimes, not only crime against humanity, but also as war crimes in their domestic laws. Similarly, we also have a case by USA in the cases of Yamashita, where again, the person was being inducted for the violation and acting as a commander when they were committed such atrocities. And that is the reason why. Right. Okay, thank you. Just one thing in the concluding thing is that by looking into United Nations War Crime Commission, what I feel is that it helps us to build the customary international law with regard to the sexual gender-based violence, as well as at the same time, it will allow us to look into how these member countries, in fact, have debated in their own jurisdiction. Okay. I don't know how to get hold of that document, but I would like to look into how India, in fact, has contributed, and the documents which India has prepared with regard to their contribution in United Nations War Crime Commission. Really sorry for eating up more extra time. Thank you.
Thank you so much. Absolutely fascinating conversation. I look forward to seeing it in writing. Do correspond with me and also in the chat. It was a great, very thoughtful contribution.
Thank you, sir.
And most welcome indeed. We do have a little bit more time because unfortunately one of our speakers was unable to join us. So I can move on to the other side of fair trials. We can say from rather than whether or not the commission sponsored trials at national jurisdictions were fair and whether the commission supported fair trials, the issue of whether or not the absence of a fair trial was itself a war crime, which is the focus of our final presentation from Dr. Marchesi. So the floor is yours, and thank you very much for joining us from Leuven.
Thank you, Daniel. Do you want me to run the recording then?
I can run it now, if that's okay.
Yeah, okay. Thank you.
Hopefully the whole thing's being recorded, I hope. Go ahead when you're ready.
Oh, sorry, 1 second.
Oh, your colleague is doing the job for you. Well, that's a great asset.
They can hear it.
You can just post in the chat and that's going to hear it.
If you have issues, I can always try to present it now.
Yes, I might have to ask you to present it, if that's okay.
Yeah, I'm a little bit exhausted because I have 6 hours of teaching today, but I'll do it gladly.
Oh, I'm sorry.
Yeah, it's a crazy day. That's why I recorded it, because yeah, I knew it was a little bit hectic today. But yeah, give me a minute and I will try to Yeah, sorry, I'm trying to find it. Do you want me to try to run the recording? Maybe because the audio.
Are you able just to speak? I mean, we don't have to waste your whole time.
Yeah. Okay. Okay. No problem. I'll just start. Yeah, I just cannot at the moment share the presentation for some reason. Yeah, I don't know. Okay. Well, I'll do my best without the PowerPoint, or you can share the PowerPoint and I will talk over it, Daniel.
Yeah, I'll do that. Yeah.
But yeah, I can start so that we don't waste too much time. Sorry about that. So hello everyone, my name is Diletta Marchesi and I'm a PhD fellow of the Research Foundation Flanders at KU Leuven. I was not supposed to be here for the presentation because yeah, I had other teaching commitment, but I'm happy to be able to be with you.
I'll share it anyway.
In the end. So as have been said actually already, I would like to discuss with you today a specific crime which was allegedly prosecuted in the post-Second World War trials, which is actually the denial of a fair trial itself. So among the trials held to prosecute Axis members for the war crimes committed during the Second World War, for the first time, there were also charges related to the denial of a fair trial to prisoners of war and civilians. The United Nations War Crimes Commission gave an account of and commented on several of these trials in the law reports of the trials of war criminals. And volume 5 in particular is presented as including most of the trials that share the common feature of dealing, and I quote, with that type of war crime, which can be rather roughly and summarily described as the denial of a fair trial. The UN War Crimes Commission chairman observed that already during the Second World War, and I quote, the customary law of war requires that before anyone, a combatant or no combatant, should be executed or otherwise punished as for an offense against the laws of war, it should first be tried and sentenced by a court whose jurisdiction is recognized by international law. Slide, please. Among these denial of fair trial cases, the defendants were found guilty on charges that differed considerably from each other, and two groups can be identified. The accused in the first group were tried for being involved in varying degrees in the unfair trials and execution of a small number of prisoners of war or civilians in violation of the laws and customs of war. The accused were high-ranking military personnel who acted as judges or prosecutors or carried out unlawful orders or had supervisory tasks over the military administration of justice. And most of these cases were conducted by Australian and US military courts or commissions against Japanese nationals. The charges in the second group were of murder and the killing of prisoners of war and civilians, in that the act was not justified under the laws and customs of war. And to prove that a fair trial was established would have involved substantiating a defense plea according to which the killing was legitimate. The trials were conducted mainly by the British, but also by Australian, French, Norwegian, and Canadian military or civilian courts. And the defendants were Japanese and German nationals who were tried for being variously involved, again, in the execution of protected persons in their capacity of, for example, judges or military personnel in charge of detention camps. So an attentive analysis of these cases shows that not all of the trials collected in volume 5 deal with the war crime of denying a fair trial, contrary to what the UNWCC claimed for that volume. Trials of the second group certainly do not, as the emphasis was on the war crime of killing without a legitimate reason to do so. So in volume 6 of the law reports, the commentators seem to have grasped more neatly the diversity between the two groups I mentioned. So one passage clarifies, and I quote, that there are two alternative ways of regarding evidence of the denial of a fair trial. One could deem such denial a war crime in itself, And on the other hand, it could be said that proof of a fair trial constitutes a defense to a charge of causing death or other harm to prisoners of war or inhabitant of occupied territory, and that proof of the denial of fair trial nullified the operation of that defense. So the trials of the first group seem to be a rudimentary, we can say, precedence of the war crime of denying a fair trial. However, it's not even clear whether the crime of denying a fair trial was considered as a separate positive crime. In some passages, the law report considered it a possibility, but in others, denial of fair trial was deemed to be a war crime. In volume 6, we then find a notable case, the so-called justice case. In this trial, as you probably know, the US military tribunal in Nuremberg convicted 16 defendants of war crimes and crimes against humanity. The convicted were either German judges and prosecutors or officials involved in the Nazi regime's administration of justice in Germany and the occupied territories. The tribunal focused on the systemic criminality driven forward by distortion and denial of judicial and penal process, which enabled German authorities to abduct those suspected of having endangered German security and made them disappear. Denial of fair trial was utilized then by the executive, and I quote the judgment here, as a powerful weapon for the persecution and extermination of all opponents of the Nazi regime and races. The tribunal stated, in fact, that the dagger of the assassin was concealed beneath the robe of the jurist. The crimes were considered not only violations of international conventions, laws, and customs of war and domestic law, but also the general principles of criminal law as derived from the criminal laws of all civilized nations. And the law reports say that there is a strong suggestion that here the tribunal regarded the denial of fair trial as itself a possible criminal act. The justice case is unique of its kind because under the spotlight, there was the unsuitability of the entire administration of justice system of that time in delivering fair trials, as the judicial system itself systematically denied fair trials to the detriment of thousands of unidentified victims. This distinguished the justice case from other post-Second World War cases, which adopted a case-by-case approach with the aim of proving the unfairness of single proceedings held against a limited number of identified victims. The post-Second World War trials experience was very important indeed. Moving from it, the 1949 Geneva Conventions prohibited for the first time the willful deprivation of the rights of fair and regular trial prescribed to prisoners of war and civilians in international conflict as a grave breach of the conventions. And Common Article 3 then prohibited in non-international conflict the passing of sentences and the carrying out of execution without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized people. And today, the statutes and fundamental laws of international and hybrid criminal tribunals criminalize such prohibitions as war crimes, adopting almost verbatim the wording of the Geneva Conventions. Although in more than 70 years of international criminal justice, these offenses have gone virtually unnoticed, we can say, having been prosecuted only 2 times by the extraordinary chambers in the court of Cambodia, the crimes are currently gaining new attention. In fact, at the International Criminal Court, the war crime of sentencing or execution without due process in the context of a non-international conflict is being prosecuted for the first time ever in the history in the Alassane case. And according to the most recent report on preliminary examination at the ICC, the OTP, the war crime has been allegedly committed also in the Ukraine and Israel-Palestine situation. So given the scarcity, we can say, here I'm still on the last slide, but should be changing at some point. So given the scarcity of other precedents and the significance of post-Second World War cases, the post-Second World War case law still represents today an important precedent for the war crime of denying a fair trial. Although it's not possible to employ directly that case law to interpret and apply the war crimes today, has the law in the meantime got more detailed, fair standard principle changed, and so forth, mutatis mutandis, it can still provide assistance in the interpretation of such crimes. However, it should also be underlined that numerous questions regarding the interpretation of the war crimes still remain unanswered, most notably on the actus reus of the crime, the violation of which fair trial guarantees amount to a war crime, we don't really know. The material elements that the post-Second World War case law has contemplated to establish the denial of a fair trial are very difficult to identify, as reasoned judgments were not always delivered. And when they were delivered, the construction of the judgment, we can say, often does not allow an understanding of what was regarded as criminal and what merely as evidence. The law reports themselves underline this difficulty in several passages, stating, and I quote, "It's impossible to draw up with certainty a complete catalogue of the aspects of the trial which were regarded as contributing to its criminal character." So this position of uncertainty exposes the war crimes of denying a fair trial, I think, to problems of application and jeopardizes foreseeability of criminalization. As the post-Second World War case law, despite providing, as I said, an important interpretive tool, cannot answer such unresolved question, we can only hope that the case law of the International Criminal Court and other international or national even criminal tribunals will clarify soon the interpretation of these crimes. In so doing, however, tribunals should avoid placing unrealistic standards on non-state and groups administering justice during the conflicts, and should abide to the principle of strict construction of crimes. Thank you very much. And I hope it was not confusing with the slides.
No, I think we all have to wrestle with the technology, which is of course wonderful, but it also,
yeah, sometimes it fails us.
It trips us up all the time. I think it's a fascinating presentation again. It's been a great panel so far, and I think your ability to look at the trial reports and present practice as well was very interesting. I've been racking my brains, and I can't remember the precise location that I came about it. And I think I do write about it in my book, but and this links back to the earlier discussions about imperial and colonial structures that I came across, and I'm sure, I hope, wrote up and referenced that the British and the Americans had to amend their manuals of military justice, which allowed for the execution of hostages in the empires, in colonial situations. The Americans, who would have been principally in the Philippines, the British more broadly, because until I think 44, their military manuals provided for executions of hostages without trial. And there was a limitation on the prosecutions of Germans for the execution of hostages on the basis of there not being a trial. That because the execution of hostages with some kind of process was permitted by the Anglo-Americans, presumably this was not pursued with the Germans, but only when they didn't have any due process. And that the Anglo-Americans themselves had to amend their manuals of military justice. But I confess I don't have a footnote, an exact reference to mind, I'm sorry. But it speaks both to your work and I think to Sophie's presentation earlier on. Well, we've had three glittering jewels of presentations in the tiara of this little seminar. I'm also aware that our parallel discussions are very fascinating, and I look forward to having a look at those when we get the video recording. but I think it's now a good opportunity for those people who have not been on the panel to intervene. Julia, George, your colleague Daniel, I think, and others to jump in. That would be great.
I just apologize in advance. I will need to leave in 3 minutes because I have to teach again. So.
Oh, I'm sorry. I know the feeling. Okay. Do you want to say anything yourself about the other presentations, or in general about the panel of the conference? The floor is yours.
Well, yeah, unfortunately, I've been able to join only now for my presentation because I was teaching. So just if you
hopefully you can come back later. But have any final comment you want to leave us with?
No, for me it's all fine. If I have some questions from the audience, I would be happy to reply. Otherwise, I will. Yeah.
Hopefully, you can rejoin us later.
Maybe I will be able to. Thank you so much.
So. Well, thank you, Dr. Marchesi. Thank you. So a slightly smaller group shortly. Maybe Professor Modi, Professor Nanda, you have comments on each other's presentations, and maybe Julia or George can jump in as well. Do please turn on your cameras because I'm feeling rather lonely. There. Thank you very much. It's the worst thing about Zoom teaching is when your students won't turn on their videos and you find yourself speaking into a black void. With this number of people, I don't think we need to be formal about putting up hands. Just jump in and shout. I'll shut up.
Yeah, just one observation on the presentation, then the last presentation. In fact, that's a very, good study which has been done, taking the fair trial concept and applying it, in fact, on the present ICC. I was just wondering is that whether the prosecution, which has already been done, by the United Nations War Crime Commission, where we are now posing the challenges of fair trial, can later on the relevance of the entire trial and the prosecution can be condemned, in fact, because that is what my thing is. Because when you look into the documents which have been given by various national courts, they say that many of the documents are not of the same level. There are the trial which have been submitted by the USA where they don't have given a proper conducted the proper trial or given just an introductory judgment, whereas you have another set, maybe the Britishers are there telling where they have given in fact lengthy reports with regard to how they conducted the trial, how they in fact asked and examined the witnesses, and then they gave the decision. So how in fact when we're looking at the value and the significance which all these trials have come out, I'm just like not having words to frame these questions in that proper manner.
It's a very good question. I'll have a go at answering it, and maybe colleagues can help here more widely. Of course, in the continental, in the Napoleonic tradition, trial records are never anything like verbatim. They're not verbatim. It's the Anglo-American tradition and the countries that follow that tradition that have a full trial transcript. Slightly surprised about what you say about the Americans, because we have on our website the full thousands of pages in each trial of hundreds of cases, and these are all digitally searchable. And as I say, it's a mystery to me that an American law school hasn't picked this up, or American graduate students haven't, because there's no shortage of wannabe doctoral students of law in the United States. That's for sure. So I'm surprised at why you say about the Americans not being full transcripts. Can you say a little bit more about that?
Not much more, but because I was reading very different articles, and in that article, one of the the person, the scholar, in fact, has stated that because of the various variations in the submission of documents, they have raised that Britishers are having a more detailed format as compared to few of the cases where USA seems to have given an introductory decision and not the lengthy one. So I've not gone into those cases by myself, but have depended on the view of the scholars.
If you share with me, I'll try and give a more detailed response. But if you look at
Definitely.
the full trial transcripts on our site, you'll see that the general habit is to be extraordinarily detailed and verbatim. But interesting point. Good to have you with us, George.
Thank you very much, Rick. I'm just, by way of introduction, I'm a guest lecturer on war crimes at Edinburgh as part of their ICL program at the Masters. I'm teaching next week, so this is a great prep for me.
Okay.
I was listening intently both to the keynotes and to the session here, and it's interesting that you mentioned about the amendments regarding the hostage taking, and the somewhat about the controversy around recognizing that there's almost that reflective aspect of prosecutions and war crimes, where in breaking down the concept of, well, the accused is always the enemy, and that the modernization of international criminal law is the equality of all before any war crimes prosecution. This idea that it causes us all to look back at our own practices and to say, this link between, well, the perpetrator is the enemy as compared to the perpetrator can be anybody involved within the nexus of the armed conflict.
Yeah.
I found, I was reading Guilfoyle's text earlier this week as a refresher, his first edition, and he mentioned about hostages as well, the idea of the taking of hostages and the complications that arose from the notion that the Allies did it as did have this as an option. So I find it fascinating to look back at these times and say this really is sort of an advent period of shifting from. I believe I agree with the notion that international criminal law is not necessarily victor's justice, but it causes victors to maybe look at themselves and ask some pertinent questions.
I think one of the documents which we found, and it's on our website, is the document they prepared for ECOSOC when it was developing the Universal Declaration, which is amongst the key resources in the research pages on our website. And they wrote this in the dying days of the Commission, and the title is deeply counterintuitive to what most of us would learn, which is the implications for human rights of the war crimes trials then underway. And the fact that they wrote this reflective document, and there's an extensive discussion of the rights of the accused in that document. It's about a 400-page document, and then was completely classified until I think 1990. And then we were the first people to ever read it, as far as I know. But it's a great thing to give the students as evidence. And I keep harping back on the politics of this, and I don't want to dominate the discussion, but the fact that the Commission, we often refer to the law reports and the history. If you think about the modern world, any organization that publishes its own official history in the year of its closure, the rapidity that they felt they had to do this before the exigencies of pro-German sentiment in America slammed the door shut on war crimes in general. They had to get published before the door slammed shut. The publication of a history in the same year you closed is, extraordinary.
Well, I think very much, and again, yes, we don't want to perhaps linger on the politics, but the idea that law in and of itself in these moments becomes a competitor for national histories or national narratives that are going to be put forward post-conflict, that it's one of those rare occasions where law itself plays a very strong hand in the narrative for
notwithstanding the imperial and racial dimension, the introduction to that, I think Lord Wright's introduction to the history, the introduction to this ECOSOC report, where they say, and it goes back to the St. James's Declaration, that these states and peoples invested political will and ideology, which came back to bite them with respect to their empires, in the rule of law as a means of differentiating themselves from the way the Axis were behaving. That the extreme behavior of the Nazis required this, if you like, this antibody reaction of building up human rights. Anyway, I'm dominating the discussion with you, George, but try to bring in the audience. But Julia, Professor Modi, would you like to jump in and join us?
I think, yes, I would like to join, because I think I haven't done much research on other aspect which has been discussed by Bhumika, Nanda, and other speakers, because much of my understanding was regarding these cases. So that is, yeah, yes. So I think this was very interesting thing for me, that, and I would love to coordinate and wish to understand these things more. That is
okay.
What, yeah.
That's fine. That's fine. Daniel, do you want to join us? I know your colleague Daniel had to go, but if you want to say anything, you're very welcome. Perhaps not.
No, I'm all good. Thank you. I'm just sitting here quietly listening. Thank you.
Okay. George, Professor Nanda, do you want to contribute or ask me anything more on the topic? I'm very happy to have more discussion.
I perhaps have a question for Professor Nanda with regards to sexual and gender-based violence and conflict. Do you find, or somewhat of a self-answering question, but the perspectives taken both in law and in the description of the actual offenses themselves reflective of social attitudes at the time versus the development of gender and sexual violence as crimes in today and post-Yugoslavia, post-Rwanda? Does a lot of your work follow the sort of development of the crimes that you work with? Does it follow that social development and differing perspectives now that we have more input from TWAIL and gender perspectives, and less, say, the concept of conflict being more a male perspective?
Yes, I would say definitely yes to that, because we have traveled a lot in this context when we talk about sexual and gender-based violence from World War time, and now with the examples and the incidents of Rwanda and Yugoslavia. But my only thing is that especially in Yugoslavia and all the more in Rwanda, more of the offenses were being done with that purpose, where you'll see the mass level of sexual offenses being done with an objective of, in fact, committing those offenses to propagate their ideas. That is something which I didn't see when I was reading the trial reports of the United Nations War Crime Commission. So there, the objective, so it happened, they did that while for, torturing and raping the women of those countries, but the objective was not to use that as a policy at that time. I didn't see that coming out with the kind of cross-examination was done and the kind of question being posed. But when I read the cases from Rwanda, as well as the cases which are being heard right now before the ICC with regard to gender and sexual, the planning has been done with that regard, with regard to the committing those offenses. So that is why the reason I believe that a lot of development has been done with regard to the cases and the jurisprudence of sexual gender violence after the Rwandan tragedy, and now being taken up by the ICC enormously. So I think that would be not exactly an answer, but that would be an extension of what you were in fact stating.
I might just add, hard to imagine this, but and perhaps easily forgotten, but under Nazi law, Germans could be punished for having sex with subhumans. The subhuman races, you know, the idea of crossbreeding with the subhumans could get to German executed.
Yes, that's sorry, I missed that. Yes, but that was one of such thing of having only a pure class.
Having a pure racial class, which is,
race.
you know, a level of extremism almost unimaginable, because, you know, traditionally, you know, you might assume from let us say a caricature of patriarchal struggle that you know, subhuman females would be quote unquote fair game, but no, and of course, you know, rape of Jews and so on was very prevalent as well. We know that the law, the Nazi regulation, was not adhered to, but it's worth, you know, remembering what the formal position was.
No, I mean, again, it reminds me, sort of just looking at the link necessary from Kunarak that, you know, was the commission of the crime in terms of the actual person committing the crime, was it part of the purpose? You know, absolutely. There's the ability to commit the crime, the decision to make the crime, the manner being the focus of what we're talking about in this question, but the purpose, I think both of your points speak to the purpose. You know, gender and sexual violence as being part of a purpose of a wider spread conflict. In World War II, as you said, you know, this idea that it occurred, but there were laws against it. But if I look at something, say, more around, let's say, Lubanga, the Lubanga trial, or Sierra Leone, you know, the idea that gender and sexual violence being used towards your own side, quote unquote, the idea that its purpose was very different in those instances than it was in World War II, but also the aftermath of World War II and you know, the rape of the Red Army across Europe. You know, this idea that it can happen in the conflict, but it's interesting that post-conflict, you know, with the return of the Red Army and the rape of the Red Army, that wouldn't have been caught in the same legal net without that.
Absolutely not. I don't want to be misunderstood here on the issue of the Red Army, which, you know, the rapes were appalling and there's no excuse, but one needs to be careful of post-war German revisionism. The communists, the Red Army, did not behave in Germany as the Germans had behaved in the Soviet Union.
Absolutely.
They did not exterminate the population of Berlin. They did not starve them to death and reduce the population to zero, as was the Nazi plan in the occupied territories, and even the plan for France, you know, of von Rundstedt and so on, supposedly just the German generals, was to depopulate France by starvation. And what, you know, instead of, even in Greece, what, half the population, half the children had died of malnutrition. And this wasn't the policy or the practice in Germany and Eastern Europe of the Soviet Union, which is not to excuse Stalin or communism or anything else, but one needs to be wary of various, I hesitate to use the word, but almost tropes emanating from post-war German revisionism.
Yeah, no, my point was more to speak to the Nexus requirement for war crimes.
Absolutely, yes. And forgive me if my response was inappropriate.
No, not at all. No. You highlight a good point. What I find intellectually interesting, it is the nexus requirement. That proximity to a conflict pre and post is a point of contention if we were to look at bringing certain prosecutions. I find in some instances the temporal limits of jurisdiction have interesting effects on the way that, well, as you said, I mean, it can lead to revisionism, it can lead to whataboutism that's entirely inappropriate, but the actual acts themselves can very much reflect each other.
Yes,
and
well, it's a fascinating conversation. We are now, I think, out of our extended time, and we can probably carry on